Good afternoon, and welcome to the Momkus McCluskey Asset Protection webinar. This is the second of a series of webinars that we're putting on to give a better handle to business owners and executives about the basic structure of how we can do asset protection. And our purpose today is to give you an idea of how to organize your personal and business assets so that you can make advantages of taking this business protection up to the easiest and most efficient way in which you can do it. My colleague Neil Goldrum and I will be your hosts. Let's start with an overview of what we will cover. First, we're going to talk about the underlying concept behind asset protection planning and how it works. Second, we're going to talk about business assets and the kinds of risks that businesses have. Third, we're going to talk about some of the tools we use to protect business assets. Fourth, we're going to very briefly talk about some of the advantages of accounts receivable financing in asset protection. Fifth, we'll talk about insurance and its role in asset protection planning. And then finally, we're going to apply some of the principles we will have already discussed to personal assets and talk about some particular tools that we use that only apply to personal assets. So with that in mind, there are many misconceptions about what asset protection planning is designed to accomplish. So let's briefly talk about what it is that we're actually doing. Most fundamentally, what we're trying to do is to make sure that involuntary creditors need to negotiate with you in order to get paid. We're hoping that we can put you in a position that you pay only cents on the dollar in the case of an involuntary debt that you owe. So what am I talking about when I say involuntary creditors? An example would be an injured person who sues you and obtains a judgment. Once they get a judgment, they are a creditor of yours and would proceed to try and liquidate some of your assets. A voluntary creditor, on the other hand, is someone like the bank that you want to borrow money from, and that bank may require that you sign a personal guarantee in order to get the loan. But that's something that you actually bargained for and expected. An involuntary creditor is somebody that you really didn't even have on your radar scope, and now you find that you owe money to that person. Now that we've established the goal of asset protection planning, which is to put you in a position to negotiate a cents on the dollar deal, let's discuss when it's important to act. It is really critical that you act before you actually have a judgment against you. And that is because of a legal concept known as the fraudulent conveyance. In essence, a fraudulent conveyance is a transfer of assets where you intend to defraud your creditor. And the courts and juries are entitled to look at what we call badges of fraud to determine whether or not a conveyance you made is fraudulent. So an example might be is that you have gotten a judgment against you, you owe someone $2 million, you thought that you would then make a transfer of all of your assets to your children, and you'd make those transfers after the judgment has already issued against you. It is virtually certain that that will be treated as a fraudulent conveyance, and any asset protection that you hope to get out of that is not going to be useful. A couple examples you'll see of a fraudulent conveyance and badges of fraud are the fact that you know that litigation is threatened against you, you know that you're transferring virtually all of your assets to someone, leaving yourself penniless, or you try and do the transfer in a way that is concealed. In other words, you try and make sure that nobody realizes that those assets were transferred. All of those things have been found in the past to be evidence of a fraudulent conveyance. What all this adds up to is that the sooner you act to implement an asset protection plan, the greater the likelihood is that all the details of the plan will actually be effective. Let's now focus briefly on the types of things that can create a liability for businesses. Obviously, to some level, you can have a liability that you created personally. This can be the case with doctors, accountants, dentists, architects, lawyers, where you commit a professional malpractice. That's a liability that relates directly to something that you did personally. However, when you're a business owner, you have employees and other agents who act on your behalf. And in those circumstances, you become liable for the things that they do that might be negligent. So, as an example, an auto accident that occurs when one of your employees is delivering a product actually becomes a liability that is a liability of the business, not a liability just of the employee. You could also have general negligence in your business. You might run an excavating company and make an error as to which piece of ground that you excavated, in which case you're liable for all the damages that come out of that. You can also have liability that arises just because you own something. Owners of property are responsible for the things that happen on the property, such as a basic slip and fall during an icy season when you should have actually cleared a sidewalk. You might have an investment property or a summer home that you rent out. Similarly, just the mere fact that you own the property may make you liable. And finally, there are situations where you actually enter into a contract for personal liability. An example may be when your business borrows money, but in effect, you also have to sign a personal guarantee in case the business is unable to pay that money back. So, what do we do to accomplish the asset protection planning? We draw from tools from three disciplines. One from business planning, financial planning, and from estate planning. And the first thing we're going to focus on is the tools that we draw from business planning. Most of you probably already, to some level, engage in some sort of asset protection planning, and that's simply having a corporation or an LLC rather than doing business directly. And I think most of you are probably already familiar with that concept. We build on that concept by going and taking another step by actually subdividing other aspects of your business into different entities. So, a corporation or an LLC is a separate legal person, and when you're acting in the capacity of another entity like a corporation or an LLC, the liabilities stay with that entity, and in fact the assets that are your personal assets, such as your home, are excluded from being reached. So in business, the most typical entities used are corporations and LLCs. LLCs are limited liability companies. In past years, limited partnerships were regularly used as another asset protection tool to limit liability, but in fact, those have fallen out of favor with the advent of limited liability companies because limited liability companies are more effective and simpler to operate. Now let's focus for a minute on corporations. Corporations, being a separate legal entity, are protecting you because you title your assets into that entity, the assets that are used for the business, and you make sure that people that are employees of that entity make known to everyone they deal with that they're dealing on behalf of the corporate entity. This means that officers and directors are not personally liable for injuries caused by the negligence of an employee. Rather, it's the business that is responsible. So this asset protection planning can extend beyond just the owners to actual officers and directors of the company. Limited liability companies, though they have not been around as long as corporate entities, have become increasingly popular because there are several advantages in using a limited liability company for asset protection purposes. Not the least is the fact that with a corporation, a creditor can sue and obtain your stock in a company and actually become an owner of a corporation. Things don't work the same way in an LLC. In fact, in an LLC, no one owns any of the assets individually. They simply have a right to the participation in the proceeds of the business. So there's a thing called a charging order that would issue by a creditor who's trying to get at an LLC interest. Also, there are times when an LLC is necessary because there are limitations on some corporate entities, such as Subchapter S requirements. So increasingly, LLCs are used as a primary business entity, and not the least of which is because they're asset protection advantages. So the principles of what we do when we use corporations or LLCs is to split things up in a logical fashion that isolates potential liabilities. And you'll see on this slide a series of these liabilities. For example, a liability that arises simply because you own the real estate. You could put the real estate in a separate entity. A liability that arises because of the equipment you're using. That equipment can go in a separate entity. So as an example, it may be that if you don't want to expose the value of the real estate to a potential involuntary creditor, what you do is you own that real estate in a separate entity. So if the accident or negligence comes from the operating entity, the entity that owns the real estate is not liable for that injury. Similar things apply to removing cash from business. Sometimes people leave cash in business for convenience, but leaving cash in business leaves an easy asset for a creditor to chase. Regularly removing cash from the business makes a lot of sense from an asset protection standpoint. Qualified retirement plans, which we'll talk about in more detail, are excellent ways of protecting your assets. They have protections that prevent creditors from reaching them. And so on, and subdividing different aspects of your business operations into different entities. So here you see the general principles that apply when we split up a business into multiple entities. Multiple locations are fairly typical. We have represented a client that had many truck terminals, and the client, in fact, stored hazardous materials at each truck terminal and wanted to isolate each truck terminal. Other clients have leasing operations that operate out of a separate building from the building in which they manufacture and sell. Splitting that out as a separate business also makes a lot of sense. Real estate is probably the single biggest and most basic way in which you should split up the assets in your business. We have found very few circumstances where it didn't make sense to go ahead and break out real estate into a separate entity. We would strongly advise virtually all clients to do that. There are interesting side effects that happen from that, not the least of which is that there is a logical way to move cash out of the operating entity, because the operating entity needs to pay rent. There is a completely logical excuse to be moving cash out of the operating entity even when a judgment is pending against you. Now the cash is going into the real estate entity and can be distributed from there. The similar concept that applies to real estate can apply to equipment, especially heavy equipment where dangerous operations take place. Moving heavy equipment and leasing it back to the company that is operating the business is another very basic way of splitting up business assets. Again, it also allows cash to be moved out of the operating company in a legitimate way because you're paying rent. And in fact, that applies generally to cash of all kinds in the business. It's generally a bad idea to leave excess cash sitting in a business, and instead it should be distributed as soon as possible. All right, at this point, Neil Golterman is going to take over and talk about qualified retirement plans.
Thank you, Ed. To further the conversation about legitimate ways to remove cash flow from the operating entity, qualified retirement plans are an excellent tool for many reasons, especially here in Illinois, as well as with many other states. Qualified retirement plans are creditor protected. That is, that a creditor cannot automatically go to a court and argue that the investment funds in that 401k or IRA should be used to pay that judgment. Of course, later on, when distributions are being made, it's possible the creditor still could be around. However, the point is that currently it's good planning to have for retirement, and there is that asset protection component. Also, with regard to Ed's conversation about separate entities, another opportunity for segregating assets, which protects those assets and also provides a legitimate way to, again, have cash flow exiting the operating entity, is creating a limited liability company to hold and own intellectual property rights such as patents, copyrights, and trademarks. You would enter into a royalty agreement between the IP entity and the operating entity so that royalties are being paid. And as Ed noted, that's a legal contract and obligations where the operating entity is making payments to another entity that you own, or maybe you've set it up so that maybe a next generation of owners are involved. Another method for, again, separating out assets, if you will, and removing cash from the operating entity is creating an entity that will actually have all your employees and then by agreement providing them for one or more of your other operating entities. In essence, what you're doing here is providing your own outsourcing agency. But again, with arm's length transactions and agreements, these are all legitimate uses of these different entities. Accounts receivable, obviously a big part of most businesses, and a big asset, and the question always seems to be how can we speed up the payment process for those accounts receivables. One method potentially is to make a loan against the accounts receivable, which then increases your cash flow. Of course, the negative there is that with the lender involved, there's going to be something less than 100% that comes back to you, but the lender will also have a lien against your accounts receivable. This, again, to a judgment creditor, is not going to look very collectible, and it's going to make it harder for a judgment creditor. And that's one of the themes that we're talking about here is you're making it hard for the judgment creditor to collect on a judgment. Our next slide lists business and personal insurance. Insurance protects our assets. That is, if a claim is made against your businesses or against you personally, there should be insurance to be in place to cover the potential liability. It's important to review all of your insurance coverages, both personally and for your business. This is to make sure that you have adequate coverage and coverage for all of your risks. This includes all areas of your business and investments. For example, if you are a landlord, whether it's commercial or residential property, you should have landlord insurance. If you have boats and ATVs, you need to make sure these are adequately covered. Recently here at the firm, we represented a husband and wife who had an auto insurance policy in place with a $300,000 liability coverage. Certainly that exceeds the minimum requirement for Illinois law, and they may have had some savings on the premium that they paid. However, that wasn't enough coverage when the wife was in an accident where the other driver suffered an unusual injury to his hand and arm, basically debilitating him and making it difficult for him to continue earning a living. That injured individual hired a lawyer. They made an initial settlement demand of $3 million. The insurance coverage obviously did not come close to covering that. However, we were able to successfully negotiate a lower settlement, but the family still had to use their own assets to pay $1 million to settle the case. This is why we strongly recommend review of your insurance coverages as a way to protect your assets. Also, at the bottom of our list on this slide, you'll see the term umbrella insurance. We think umbrella insurance coverage is a viable part of any asset protection plan where you are engaged in many different activities. In the case that I just described, if the family had a $1 million auto coverage policy and had at least a $1 million umbrella coverage, they would not have been required to pay out of their own family assets to resolve that issue. Captive insurance companies are another way to create a separate business entity and actually opens up a new business opportunity, and that is in the area of insurance. Again, creating an LLC to provide your operating entities with all of the insurance needs can be done in many instances. Such a captive insurance company can reduce your insurance costs in various ways. And there's a collateral benefit because of the insurance being issued by the captive. The operating entity is required to make premium payments to the captive, which either you own or you've set up to be owned by maybe the next generation of family business owners. We're going to be talking about various topics of protecting personal assets. Primarily, we'll discuss trusts in various ways and uses. This includes irrevocable trusts and different entities for a vacation home, and then we'll wind up with asset protection trusts. Trusts are generally going to be a written agreement, and they're going to involve the trust maker, the trustee, and the beneficiary. The trust maker is the person. Maybe it's a family member who wants to make a gift of assets to the next generation of family, and they're either minors or perhaps too young to just give the assets outright at the time. So the trust maker will create a trust, make an agreement with the trustee where they're making a gift. That trustee may be a different person than the trust maker, and then describes how those assets are to be used through the trust for the benefit of the next generation of beneficiaries, the family members who are supposed to receive the benefits of those assets. And you can use almost any asset, but again, maybe it's all or parts of operating entities. Could be that captive insurance company that we're talking about, but it could be almost any asset. Revocable trusts are trusts that, by the very nature, can be amended or canceled at any time by the trust maker, also known as the settlor. These kinds of trusts generally are not asset protection devices in their own right. They're used for estate planning. They're used to minimize potentially estate taxes, but they will not minimize income taxes in most instances. But again, it's a tool that's there for use in overall planning. Irrevocable trusts, on the other hand, do provide a few more opportunities for asset protection from the standpoint that the trust maker is then giving the assets to the trustee and therefore the trust, and they are no longer the owner of that particular asset. Therefore, the trust maker's creditors are not able to collect against those assets. Also, because of the nature of these trusts, the beneficiaries who will benefit from the use of that asset are not technically the owners either, and therefore their creditors are not able to attach those assets directly. At the bottom of this slide, we have the term limited term trust, and these are a very specific use trust for different purposes, sometimes in making charitable gifts, sometimes in making investments that will benefit a particular beneficiary for a period of time, and with the asset perhaps reverting back to the original trust maker, or perhaps being directed to another beneficiary, whether it's a family member or perhaps a charitable institution. Here in Illinois, we have a form of ownership of the homestead property, the primary residence for a family, known as tenancy by the entirety. This is a form of joint ownership, just like joint tenancy, which is a traditional method for a husband and wife to own property. However, by law, there is a little bit of asset protection from the standpoint that the judgment creditor of just one of the spouses cannot force the foreclosure of the primary residence. That is, as long as the husband and wife own that property as tenants by the entirety. And also, because of recent changes in the law, if you are owning the assets, that primary residence, that is, through a trust for estate planning purposes, you still maintain that bit of asset protection against the judgment creditor, again, of just one of those spouses. Oftentimes, in the right circumstances, we'll recommend that a vacation home or second home somewhere, whether it's in Illinois or in another state, be held through a limited liability company. This is good, particularly where that home is going to be used by people other than your family, and especially if you are renting that home. We talked earlier about insurance, and we talked earlier about liability protection for the entity, so that would apply in that situation. But it's also the entity, in combination with the use of a trust, a good method for creating the rules for use of that vacation home for subsequent generations, and as well as passing on ownership to those generations. The last topic we're going to talk about at today's webinar are asset protection trusts. These are a variation of the trusts that we're talking about, and they're going to be irrevocable trusts that can't be changed. And we're also talking about a trust that the trust maker uses their own assets to fund those trusts. And so the term self-settled trust is used, or self-settled asset trust is used. Traditionally, such trusts have not been allowed to be used to protect the trust maker and the assets where the judgment creditor is claiming that the assets were used simply to avoid liability, and where you're just owning those assets and trying to avoid them being subject to any kind of creditor. And in particular, here in Illinois, that is the case. We do have more than a handful of states now in the U.S. that are, by law, creating some form of what's being called a domestic asset protection trust. And it's simply that they have changed the course of their legal history to say that such asset protection trusts are appropriate in given circumstances. In those circumstances, the law generally provides for you have to give up control, of course. There's limited access to the principal in those trusts, and in some instances, those assets are still reachable by certain creditors. As opposed to domestic asset protection trusts, those that are being used somewhere in one of the applicable states in the U.S., we have international or offshore asset protection trusts. These have been around for a long time and generally have been used in situations where you're simply providing a roadblock to a collection by a potential judgment creditor. Those roadblocks are fairly obvious. Since we're going to an international jurisdiction, a separate country, the laws of that country will apply. Many of those laws promote secrecy and promote the difficulty in removing assets from the trust or from that jurisdiction. Also, a creditor has to use a local lawyer in that jurisdiction to force the trustee to disgorge any of those trust assets. Further, with those offshore asset protection trusts, creditors have to prove their case all over again. Again, this is basically the way they have their new laws applied, and will require a new trial. Some of the other rules include not allowing contingent attorney fees, which are common here in the U.S., but not allowed in these foreign jurisdictions. Also, compliance with local laws will require a litigant to purchase a surety bond in order to file that lawsuit, because again, their local laws will say that the loser pays costs. That's something that's different from what we encounter here in the U.S., where each party pays their own litigation expenses. We think that asset protection trusts are a good tool in the right circumstances. There certainly are some negatives to their use. Talked about some of those, obviously, here in the U.S., where there are limited states that actually allow self-settled asset protection trusts. Also, there's an expense attached, whether it's a domestic asset protection trust or going offshore, to setting up these trusts, and then the ongoing administration for these trusts. Not to be treated lightly is the increased scrutiny that is garnered by the IRS with these offshore trusts. That's because of the abuses that have been seen and the secrecy that is often found. Quite simply, anytime an asset protection trust is used, especially when it's an offshore trust, it's not for hiding assets, and it's not for hiding income and not reporting income to the IRS. However, recent history has advised us that some of these trusts are used that way, and that's why there's this increased scrutiny. That concludes our presentation today on asset protection. We thank you for joining us. As indicated, although we touched on some topics that revolve around estate planning, we really didn't get into the details. We'll save that for another webinar and another day. We just wanted to also reiterate that asset protection is not a one-size-fits-all kind of thing. It is the individual facts and circumstances of a particular business, family, ownership situation that result in implementing various tools that will be good for business and be good for the family and their asset protection. Thank you for joining us, and if you have any questions, we certainly will be available to answer those.